This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about rescission for a lie on an application and why failing to tell your insurer about a prior conviction for insurance fraud turns out to be a material fact to the decision of an insurer to insure or not insure you, and that conviction voids the policy. Jose Palma appealed the trial court's summary judgment in favor of Allied Trust Insurance Company that found a lie about a prior insurance fraud conviction was a material misrepresentation, causing the insurer to rescind the policy. In Jose Palma versus Allied Trust, an August 13, 2024 decision of the Court of Appeals of Texas, the Court of Appeals agreed with the insurer. Palma had purchased an insurance policy for his home with Allied. During the policy period, there was a fire at Palma's house. Palma submitted an insurance claim under the policy only to be faced with the discovery by the insurer of a prior conviction for insurance fraud that was not disclosed on the application for insurance. Allied rescinded the policy, stating that Palma's misrepresentation rendered the policy void and that it would not have insured Palma had Palma disclosed his prior insurance fraud conviction. Palma, unhappy of course, sued Allied for breach of contract and a litany of bad faith charges. Allied answered and asserted the defense that it rescinded the policy because of Palma's material misrepresentation, among other affirmative defenses, and moved for summary judgment. Allied's summary judgment motion asked that the court agree that the policy issued to Palma was void due to Palma's material misrepresentation in the policy application, that he was never convicted of insurance fraud. Allied argued that Palma misrepresented material facts, and in support of those elements, Allied submitted 5 damning exhibits. 1, the policy application. 2, the policy. 3, the DocuSign certification of completion. 4, correspondence with the insurance agent. And 5, Palma's criminal conviction for insurance fraud, a public record. The trial court rendered a final summary judgment in favor of Allied. Palma argued that whether a misrepresentation is material is a question of fact, both under the insurance code and common law, and therefore summary judgment was improper. Allied countered that there was ample, undisputed evidence in the record to show that Palma's misrepresentation was material and no evidence to the contrary. The policy application included a statement that Palma agreed that the policy would be void, quote, if such information is false or misleading in any way that it would affect the premium charged or eligibility of the risk based on company underwriting guidelines. The purpose of summary judgment, of course, is to provide a method of summarily terminating a case when it clearly appears that only a question of law is involved and that there is no genuine issue of fact. Various elements of claims may be a question of fact where there is an actual genuine dispute between the parties about the facts. However, when no genuine issues of material fact exist, a court may properly grant summary judgment because there are no facts to find. Allied submitted its undisputed evidence establishing its affirmative defense. Palma did not respond with evidence to dispute the facts as stated by Allied. He couldn't get around the public document that proved he had been convicted of the crime of insurance fraud, but simply the plain language of the statute indicates that a policy provision rendering the policy void or voidable for any false statement is a defense if the insurer demonstrates the misrepresentation was material to the risk or contributed to the contingency or event on which the policy became payable or due. None of these requirements obviates the insurer's ability to obtain summary judgment on its defense when the facts, as in this case, are undisputed. In my opinion, a convicted insurance criminal lied on an application for insurance, obtained a policy based on a lie, only to have his home accidentally catch on fire and burn, resulting in a major claim. The insurer learned of the conviction by searching public records and, based on the lie, rescinded the policy from its inception because of the material misrepresentation about the plaintiff's criminal record and prior conviction for insurance fraud, which, of course, made him uninsurable by any logically based insurance company. And so the court affirmed the rescission. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,850 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. The videos are free, as is the blog. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.